The first one concerns Romania. We have with us in presence Cristina Sambuan, that is a professor at the Artifacts University of Bucharest. Besides, she coordinates the Romanian group of the Réseau Académique sur la Charte Sociale Européenne. So thank you very much for being with us, and the floor is yours.
Thank you very much. First things first, I want to say that I'm very grateful that I'm here.
Yeah, you should speak closer to the microphone,
okay,
because it's not very sensitive. So
okay, it is.
Yeah.
Yeah.
Good.
Good. Okay.
Yes,
Thank
right?
you. Thank you. I'm very grateful for this opportunity. I want to start by saying that I'm not so much an expert in the Charter. For me, the Charter is a realm in exploration because I anticipate a little bit. In my country, and I was listening very carefully to my colleague, to Catarina, comparing in a way the Portugal equation and our equation, which is a bit different. So Catarina complained about the fact that in Portugal, scholars and the doctrine, as we say, are not familiarized with the Charter, the European Social Charter. But on the contrary, the Constitutional Court, their Constitutional Court, is a very open, and there are many decisions that make reference to the Charter. I can say, and they have also, and she said they have also quite a pretty good list of social rights in their constitution. Listening to that, I made instantaneously some comparisons with our country. We have also in our constitution such a very pretty good list of social rights, we can say that. But when it comes to, and I anticipate a bit, I would illustrate with some examples. When it comes to the Constitutional Court, and generally speaking with our courts in Romania, the Charter is largely invoked. But obiter dictum, as Catarina said, among others, provisions, similar provisions from other international treaties of human rights, not in a manner, in such a manner, so to change or to have an effect on a palpable effect on the final decision. And I think that is happening because the European Social Charter is almost a terra incognita for not only for the doctrine and also in a way for the courts. Not that the Charter is not known. I think there is no treaty of labor right. I'm mainly a lawyer in labor right, and that's why I was very interested in the Charter. I discovered Charter relatively late in during my PhD research. I had a multidisciplinary theme at the frontier between labor law and human rights law, and I was compelled to extend a bit my research because we are not very familiarized with human rights in Romania, and I think there is a good explanation for that, because our specific equation is that we entered in all these treaties relatively late. So when Western countries during the 70s and after entering into force of the European Convention of Human Rights, the Western countries, all these late after 50s and 70s and all the last half of almost, I think, 30 or 40 years, they exercised the practice of human rights via the case law of the under the monitoring mechanism of the European Court of Human Rights. During this time in Romania, we experienced a rather totalitarian regime, which was in a way disconnected from all this practice. So for us, at the beginning of 90s, when the communists fall and all this history, for the practitioner and for the relevant actors in the judicial arena, it was such a tsunami of legislation that had to be adapted to a new reality. And so I think one good explanation, so if the Western European countries, people are complaining that the doctrine is not familiarized with the European social data, you can imagine the situation in our country. And I think a good explanation is because we were very focused on adapting the legislation, on adapting the case law, and having as a reference those international bodies whose mechanism of monitoring mechanism were more compelling, the European Court of Human Rights and the European and the Court from Luxembourg. So I think that is a good explanation. And so we even though in our country there is do not get me wrong, we have a very, very well developed branch at the doctrinal level of labor law. And I'm speaking of labor law because the European Social Charter is impacting in a quite important way this branch of law. Even though we have a very well-developed branch of labor law, national labor law, and people are getting more and more informed and keep the pace with the case law of the Court of Luxembourg or the Court of Strasbourg, because even the European Court of Human Rights, it has a social case law. The European Social Charter is cited almost mainly at only as the treaty, but not with reference to the case law of the European Committee of Human Rights, which I think is a very huge difference, because that makes the difference, because the substance of the Charter, and usually speaking, the substance of the treaties, of human rights treaties, is coming from this important body of case law. And so I think I anticipated a little, the spoiler alert, the effectiveness of the European Social Charter in Romania. Well, it is not so impressive. But I think there is, that's why I was impressed during my research, my doctoral research, and that's why I continue to, and that's how I got to RACSE. And I know that not so much my expertise is recommends my presence here, but I think my enthusiasm for the cause. I discovered that this charter is a huge potential for the practitioners of labor law, a huge potential. And almost most of that in Romanian system. And I'll tell you why. Because speaking of Romanian constitutional system, as you can see, I already told you that we ratified the European Convention of Human Rights in middle 90s, and the revised European Social Charter in 1999 with 65 paragraphs out of 98, I guess. Romania has not ratified the additional protocol on collective complaints, and I think that this is another good reason why the case law of the committee is not well known in Romania. And we joined the European Union in 2017. Yes, you know what I mean. Okay, so our constitutional um, environment, let's say, I think it's favorable for exploiting the European Social Charter. Why? Because we are one of these systems where, and I don't know how the things are going in Italy, or we are one of that system that prioritize the human rights treaties over less favorable domestic law. And this is specified in the 20 article of the Romanian Constitution, as you see, where any inconsistencies exist between the covenants and treaties of the fundamental human rights, Romania is a party to, and the national laws, inconsistency between treaties of fundamental rights and national law, the international regulation shall take precedence unless the constitution of national laws comprise more favorable provisions. So as far as I know, I'm not very well familiar with this language of and these methods and vocabulary of the human right, because I'm a labor lawyer and teacher. But as far as I know, this is one of the first and the most important condition requirement in order to enforce the horizontal direct effect of the rights of a human right. Of course, if we have another some other conditions, such as the direct effect criteria are met regarding the concerned provisions. That means that that provision has to be sufficiently clear, unambiguous, unconditional, not require, etc., etc. So I think there are some, as far as I know, and please be free, feel free to not avoid to contradict me if I'm wrong. But as far as I know, there might be some social some provisions, some rights provided by the Charter that could have a direct effect. That even though the social rights usually they are tailored in quite not so unambiguous terms, and the case law is the one that gives substance to the right. But there are some rights which I think, as far as I know, I think the Belgium or one of the paragraphs from Article 6, the collective action, I think the Constitutional Court of from Belgium or Netherlands, I'm not very sure, they found that this paragraph, the 6.3 paragraph for collective regarding collective agreements or something like that has direct effect. And so I think this provision of the Constitution can be exploited. Well, unfortunately, as I already said, the doctrine is not well prepared for that. Although there is, I would say, there are somehow disconnected the courts. When I make my research, how many times the European Social Charter is invoked in the decision of the courts? Oh, many times, but only like an ornamental, let's say, you know, among other similar provisions from not in a way that changed the final result, not in a way that give an additional value, let's say. And this is somehow this is not it's somehow unfortunate. So that's why I felt compelled in a way to give you an overview. The topic is the effectiveness of the European Social Charter. So I can't say the European Social Charter, there are many relevant actors. First of all, the doctrine, the lawyers, the judges, the courts. Well, here we have no many expectations. As I already said, because there is no reference to the European Committee of Social Rights case law, which I think that reference makes the difference. So I felt compelled to give you an overview in order to have a graphic, let's say, glimpse regarding the situation of the articles, article by article. I selected only these are the digits, the last 2 digits of the year. So we have the periodical reports because we are not in the collective complaint mechanism. So we have to, the Romanian government present the periodical reports. I selected only the non-conformity and deferred conclusions. So as you can see, the non-conformity I marked with red and the deferred with green. So the longer the row, the longer the line, the more consistent the apprehension, let's say, the reluctance of the Romanian legislator to respond to the requirements of the charter. Let's say the second paragraph of Article 1. As you can see, there are consistently non-conformity until 2020, when was the last report, because some reports, this is the mechanism every year, another group of rights. I choose to use the committee way of dividing the rights, because they divided the rights in 4 groups, in 4 big groups. So this is the situation of employment training, health, social security, social protection, etc. As you can see, we have 3 or 5. The green one, I recall that this is deferred. We have not conformity here. So safety and health regulations, the 3.2 articles, safety and health regulation. I want to say that this is one of the articles that is self-executing in a way, because it requires, there are many ways of implementing, as far as I know, of implementing the charter at the national level, not only through regulations, not only by law, because we have an article in the charter that says we can implement. I think Lorenza had spoke about that. We can implement at the national law via collective agreements, or via practice. It is not compulsory to have the law, but of course the law is the royal way to. But look, this 3.2 article, the paragraph 2 of this third article is an article which require a legal framework, require explicitly a legal framework, and as you can see, we have only non-conformity here. So that says that that the Romanian legislator does not conform, that literally ignores the conclusion of the committee on a systematical base. I'm looking at the article with non-conformity, because where the law is okay, where the practice is okay, well, we have no problems there, because we are also under other monitoring bodies. So. But we are focusing on those articles in order to assess the effectiveness of the charter on those articles where there is a consistent non-conformity. So the labor rights, and as you see, and this is the situation of children, family migrants. And so you have a graphic, let's say graphic overview, a graphic perception of how the effectiveness over the effectiveness of the charter. But I choose to illustrate via some examples to prove a little bit my point. I choose from the labor rights list because I'm a labor law lawyer. Some of those articles that have a consistent non-conformity. Not fair remuneration, because there are, as you know, there are two types of, let's say, two types of rights in this charter. I think the programmatic rights, which are more dependent on the resources of the state, on the budgetary, or I haven't chosen these kind of rights, because I know this here are the sensitive political issues, but there are some rights like let's say the trade union liberty, trade union freedom, or the trade union rights, as an example, or information and consultation of work, or protection of worker representatives, which are rights that can be enforced at least at the legal level. And I will give you some examples of this situation, how it was perceived, which were the reactions at national levels. So let's take, for instance, the reasonable notice for termination of employment. Constantly to this day, starting from 2023 until 2018, when was the last report, the committee found that Romania is in non-conformity because we have this notice period in case of termination of employment for the 15 then 20 working days period of notice, which no severance pay in case of unfair dismissal other than retroactive payment of wages, no notice period in case of termination of employment during probatory period, no notice period in case of legally automatic termination of employment, such as the death of the employer person, or other similar cases of automatic termination. And the committee constantly found the non-conformity, but there is no reaction. And there is no reaction, no other reaction, not only at the government, but no other reaction at national level. There are a lot of debates regarding the national law, labor law in Romania, in the doctrine. But I literally do not remember being a debate on this topic, the topic of reasonable notice, of the notice of in case of termination of employment. That says that somehow the doctrine is and the courts are disconnected in a way. It is a cloison étanche, let's say, between the government, which knows the situation because they give the regular reports, and the courts and the doctrine. Another example, protection of worker representatives. Here we have, this is interesting because here we have a strong debate at a doctrinal level, but nobody's, I haven't found a scholar saying something of this non-conformity, of these reports, of these regular reports, where Romania was constantly found that it is in non-conformity with this, not constantly. This is very interesting because here we have a regression. In the first place, on top of that, this is a special situation. On top of that, at the beginning, the law was protective with the worker representatives. The problem is saying only during after their mandate, after the termination of their mandate. But after that, the Constitutional Court found that this provision protecting the worker representatives after their mandate is unconstitutional because it could be they seen it as a discrimination. But the committee said no, it's not a discrimination. It's a way of making effective the provisions of the charter. Because that's how we interpret it. But so the Constitutional Court, not only that they completely ignored, their solution is the opposite of the view of the committee. So that says, I think it speaks volumes about the effectiveness of the charter at the national level. Even though the article per se, maybe it is cited, but behind the article, it is the committee's case law. And the committee case law give the details, and the devil is in the detail. The right to strike, a constant nonconformity, no reaction at national level, based on the committee's conclusions. But there are reactions here on the doctrinal level and maybe in the courts, but nobody is citing the committee's conclusions, which are extremely relevant and could be a very good argument for a lawyer. In considering also that article, the 20th article of the Constitution, which says that the provisions of the treaty, the human rights treaties, have priority over the less protective national provisions. I give you an example of course, this the effectiveness, considering that we don't have a case law based on the committee case law. It is very difficult to have another approach. That's why my approach was based on the reports, directly on the reports. This requires the effectiveness of other articles, of course, require more in-depth research. But I think these articles, which are important articles, give somehow a glimpse on the pattern regarding the effectiveness of the Charter at the national level. So I would say that the Charter is not ignored as a treaty, but the committee's case law, which gives substance to the Charter, is terra incognita in our country, unfortunately. No, the Constitutional Court, yes, I think there are some very, they of course they know the European Committee, the case law, but there are no references because maybe we don't, this is given of the weak mechanism of enforcing of the Charter, I think. There are so many, and usually we take this, all these, you know, the decision of the Court of Luxembourg, of the Court of Strasbourg, the social decision, we take it all, well, we have it to adapt, we have it to, not with a critical eye, because we don't have this approach via on the human rights approach. No, we just feel compelled to integrate, but the social charter protection is higher in many ways. And that makes a difference. The difference between the protection of the European law and the protection of the Charter. And as we know, the European Committee says that for them the protection, the European law protection is not enough. This is, I hope,
Thank you very much, Christina, for this quite depressing but very, very useful presentation, because it's exactly what I think. So the Charter is very useful, but the more it becomes useful, the less it's used.
Yes.
It's exactly on purpose. So we use a lot the supranational sources. So we are obsessive. We know very well the European law, we study a lot the European law, but we don't study other supranational.
And not even the social partners, the trade unions, because the trade unions, they would be the first interested in that.
Yeah.
That's why I truly believe in the RACSE cause. And I think this it will be a beginning for us to know better the Charter.
No, I totally agree. And as I said before, we really, in order to enforce the Charter, we should do something at the national level. That's the point. Anyway, we have another example of use of the Charter at national level, the Spanish example that I think will be a bit more optimistic than the Romanian one. We have decided to keep it. We have decided to keep it in the end because it's I think the most advanced, at least at the moment, the most advanced example. So at least exactly. At least we can go out from this seminar with some positive feeling. So I give the floor to Jose, sorry, Manuel Carril Vázquez of the University of A Coruña, Spain, that unfortunately can't be with us today, but it's in presence, but is with us online. José, the floor is yours.
Buon pomeriggio, io sono molto contento di essere qui con voi, è un piacere e grazie mille per l'invito. And now in English. My first words are to thank Professor Silvia Borelli, Yara Aquilori, and Carlotta Rambaldi, and Department of Law of the University of Ferrara. I would like to thank them for inviting me to speak at this conference. And also, I would like to thank Professor Salcedo Beltran for allowing me to be here today, speaking in her place. Without further delay, I shall begin my speech on the subject that appears up there on the screen, entitled, like you see, the effectiveness of the European Social Charter in Spain. Here in Spain, this topic has been studied many years by scholars, but always in a exemplary way by Professors Luis Jimena Quesada and Carmen Salcedo, who are now going to be on the screen. In fact, they have, she and he, published many works on the European Social Charter and its impacts on the Spain. They have dozens and dozens publications of this topic or this subject. All of them will take up all the time of this panel, in which I'm just one more speaker. All these publications have made things very easy for me because the title of my paper asks me to give my opinion on the effectiveness of the European Social Charter in Spain. And this presupposes that I know everything that Professor Jimena Quesada and Salcedo Beltran have writing before of this subject. For this reason, my speech will be divided in 5 main sections. This helps us to know the degree of effectiveness of the European Social Charter in Spain, or if you prefer, the Spain real commitment to complying with the European Social Charter. The first is a brief historical note to contextualize the key dates in Spain relations with the Council of Europe and its European Social Charter. The second section is a very specific question. The third section offers precisely an answer to the above question. What has been said by the European Social Committee of Rights?
Jose, sorry if I interrupt you, but we can't see your slide, so this
sorry.
The slide is not turning.
I'm sorry.
So
what has happened? I don't understand. You don't see the slide.
You should share your screen, but then in a modality in which we can see the presentation, because for the moment we see only the first page. Sorry for interrupting you, but.
And now?
Now you haven't shared your screen. Now yes. Okay, now we see the second slide. Try to go on.
Oh.
Now we see just a black screen. Okay, now back. If you want, your name, I'm able to say Jose, but it's not the right pronunciation. But by tomorrow I will manage.
No problem. No problem. So you can see now.
The second slide, yes. Try to go on.
Well, I continue. So May I continue? It is possible.
Yes, we are not sure to see your presentation because
I don't know the reason. If you want to take the control for me, okay, eh?
yeah, Jose, let's go on and then we will share with the participant your presentation, okay?
Okay. Because the computers, my screen tell me that I'm share the presentation.
Ilaria will don't share your screen. We will share your presentation with the participant. We have your presentation, so we will share the screen.
Okay.
Yeah, you should just tell us when we have to turn the page. Okay.
Okay.
Thank you very much.
Okay. Bueno, pues vamos a ver. Está mostrando. Okay, thank you. Sorry, sorry a lot. Okay. Okay. No, just before here. Okay. I'm sorry. I was telling that the third section offers precisely an answer to the above question, considering what has been said by the European Committee of Social Rights through the process for monitoring compliance with the European Social Charter. The fourth section explains who is responsible for the fact that Spain is not an example or a model state in complying with the European Social Charter because the parties responsible have not wanted to assume the role that corresponds to them to guarantee the effectiveness of the European Social Charter in Spain. And the fifth and the last section refers to the immediate, present time, and the future, which are optimistic because it seems that little by little, the effectiveness of the European Social Charter in Spain is changing, and it's already on the way to becoming a reality. So let's go. Please, the next slide. Okay, thank you. Thank you very much. The European Social Charter was ratified by Spain in 1980 and it came into force on 5 June 98. Always in relation to its effectiveness, this Spain ratification contained a promise to comply with and enforce the European Social Charter, literally promising to comply with it, to observe it, and to ensure that it's complying with and observe punctuality in all its parts. And Spain also ratified the 1988 additional protocol in 2000, which also contained the promise to comply with and enforce all its parts. The revived European Social Charter was opened for signature in May 1996 and entered in force on July 1999. Spain signed it in October 2000, but did not ratify it at the time, and neither ratified the 1995 additional protocol establishing a collective complaint system. For that, it was necessary to wait more than 20 years. Indeed, Spain decided to join the Social Charter in 2021, 1 year more or less. Spain ratified the revived European Social Charter through the instrument of ratification of 29 April 2021. And in this the same instrument of ratifications, Spain accepts the supervisions through the collective complaint system of 1995 additional protocol. Both the revised European Social Charter and the protocol entered into force in Spain on 1 July 2021. All this is what binds Spain. Also, as we can see, only from July 2021, Spain is bound by the revised European Social Charter and the collective complaints protocol. However, this does not prevent asking a question, always with the aim to find out how effective the European Social Charter is in Spain. And the question is very simple. Please, the next slide. Thank you. Is Spain a model in compliance with the European Social Charter? And the answer is easy to find out. It's enough to apply the criteria for monitoring the implementation of the European Social Charter. In relation to the collective complaints procedures, from July 2021 to the present, 2 complaints have been submitted. And in relation to the reporting system, between 1982 and 2022, has submitted 34 reports on the application of the European Social Charter. The next slide, please. According to the conclusions of the European Committee of Social Rights, Spain is in breach of the European Social Charter because it's in a situation of non-conformity, even for many years, by repeatedly failing to comply with the regulations of rights contained in the following 4 thematic groups. The next slide, please. Thank you. Non-conformity in the case of thematic group 1, employment, training, and equal opportunities, Article 1.1, Article 1.4, and Article 10.3. The next slide, please. Non-conformity in the case of thematic group 2, health, social security, and social protection. Concretely, Article 3.2, Article 12.1, Article 12.4, Article 13.1, and Article 4 of the 1988 additional protocol. The next slide, please. Non-conformity in the case of thematic group 3, labor rights, Article 2.1, Article 2.3, Article 4.1, Article 4.2, Article 4.4, Article 6.2, and Article 6.4. And finally, please, the next. Okay, thank you very much. And finally, non-conformity in the case of thematic group 4, children, families, and migrants. Article 7.5, Article 8.2, Article 8.3, Article 16, Article 19.4, Article 19.6, and Article 19.10. Therefore, according to the European Committee of Social Rights, Spain is a state that fails to comply with the European Social Charter. Therefore, in response to the question we asked earlier, Spain is not a model state in terms of compliance with the European Social Charter. And here there is a shared responsibility for Spain breach to comply with the European Social Charter. Specifically, there are 3 parties responsible, and all 3 have something in common. His resistance to recognizing that the European Social Charter is a legally binding international treaty, and that its interpretation by the European Committee of Social Rights is also evolving. Indeed, there is resistance to recognizing its effectiveness, even though Spanish law is very clear and forceful on the effectiveness of the international treaties. This is the case of the Article 1.5 of the Civil Code, according to which legal provisions contained in international treaties shall have no direct application in Spain until these have become part of the internal legal order by full publication thereof in the official state gazette. This is also the case of the Spanish Constitution. There are two very specific articles in this regard. According to the Article 10.2, rules relating to the fundamental rights and freedoms recognized by the Constitution shall be interpreted in accordance with the Universal Declaration of Human Rights and the international treaties and agreements on the subjects ratified by Spain. And finally, according to the Article 96.1, validity concluded international treaties, once officially published in Spain, shall form part of the internal legal order. And this is the case of the Act 25/2014 on treaties and other international agreements. According to Article 23.3, international treaties shall form part of the internal legal order once published in the official State Gazette. According to Article 28.2, international treaties validity concluded and officially published shall produce effects in Spain from the date determined by the treaty, or failing that, from the date of its entry in force. And according to Article 29, all public authorities, organs, and agencies of the state must respect the obligations of the international treaties in force to which Spain is a party and ensure proper compliance with those treaties. This mention of all authorities is important, very important, in my opinion, and helps to identify those responsible for Spain not compliance with the European Social Charter. The next slide, please. Specifically, those responsible are the three constitutional powers of the state. In the case of the executive of the Spanish government, an example of resistance to recognizing the effectiveness of the European Social Charter is in the amount of the minimum wage. Is setting only by the Spanish government in accordance with the Article 27 of the Workers' Statute, but it's contrary to Article 4.1 of the European Social Charter. In the case of legislative power, the Cortes Generales, an example of resistance to recognizing the effectiveness of the European Social Charter is the fact that the Cortes Generales did not approve any legislative measure to put an end to the Spanish repeat breaches of the European Social Charter. Nor did it approve any measures for 20 years to get Spain to ratify the revised European Social Charter. And nor need it approve any measures in relation to the additional protocol of 1995 establishing a system of collective complaints. And in the case of the judicial power, the courts, especially the Supreme Court, the resistance was in the Supreme Court. which until 2022 has denied the binding force of the European Social Charter and its interpretation by the European Committee of Social Rights. And this in contrast to the some social courts and some High Court of Justice of the autonomous communities, which did recognize and today recognize the effectiveness, the direct effectiveness of the European Social Charter. The next slide, please. Time pass or go past and things are changing, but little by little, especially in the case of the Supreme Court, which in March of 2022, more or less 6 months ago, seems to be open to recognizing the effectiveness of the European Social Charter. There are three judgments. Here you can find the essentially of the case law. The judgments are the number 268, the second is 270, and the third is 421. These three judgments recognizing the effectiveness of the European Social Charter, but always through the control of conventionality. And this considering the Spanish Constitution, the Act 25 2014 on treaties and other international agreements, and especially Constitutional Court judgment number 140, the 2018. According to this case law of the Supreme Court, any ordinary judge may displace the application of domestic rule with the status of law to preferentially apply the provision contained in an international treaty, for example, European Social Charter, without such a displacement resulting in the expulsion of the domestic rule from the legal system, as is obvious, but rather is mere non-application to the specific case. The analysis of conventionality is not a judgment of the validity of the internal norm of its immediate constitutionality, but a mere judgment of the applicability of normative provisions, the selection of the applicable law. Yes, little by little, progress is being made, but ideally, as Professor Luis Jimena Quesada and Carmen Salcedo Beltrán state, all public authorities should be obliged to comply with the European Social Charter as interpreted by the European Committee of Social Rights, and that in the face of resistance or refusal to comply with it, the courts guarantee his application because compliance with and preferential or prevalence application of the European Social Charter is a requirement of rule of law. Of course, this is clear in lower courts, social courts, and High Court of the Justice of the Autonomous Communities, but not in the Supreme Court itself. That is all. I hope I have not bored you too much. Thank you very much. I think I finished on time, more or less 22 minutes. Thank you very much. I'm sorry.
So thank you very much, Jose, for this brilliant presentation. And as I announced, Spain is an example because, as you said, keep moving forward, even if it's difficult, keep go on and try to really reach the result. And as Professor Caril Vasquez said, in Spain, there was really a group of lawyers committed to promote the European Social Charter, and they succeeded. Now the European Social Charter is used by the tribunal to disapply national legislation not consistent with the Charter, and I think Spain is the best example probably now in Europe. Okay, we have more or less 35 minutes, half an hour. I think we can open the debate. I know that there is already one question, so if you want to come here to introduce yourself, you need to speak in the microphone. If not, at home they don't listen to you.
My name is Elena Sichenko. Currently, I work at the University of Bologna. I would like to thank all the speakers for brilliant presentations, and I have a question for Katarina. Katarina, I was really impressed by your thoughts about the lack of promotion of the European Social Charter. And actually, I started to think, what do we do as labor law teachers for the promotion? I started to analyze the teaching plan for my labor law course in Russia when I was working in Russia. And I thought that among kind of 40 hours of labor law, I had 5 minutes on European Social Charter. So I think this is a good illustration of our general attitude. And I know that my colleagues who do not do anything in international labor law do not dedicate a minute to European Social Charter. And this is what I wanted to ask. Those national decisions which you presented as examples, can we understand from the text of this judgment if the link to the reference to the European Social Charter was upon the will of the court, or it was within the presentations of the arguments memorandums of either of the parties? Because it's really very important. I don't think that the courts can do it by themselves because they are normally overwhelmed by the quantity of work they have. So it is up to the lawyers to do it. And I know that in Russia, for example, there was a huge movement between the lawyers to promote the European Convention on Human Rights. And they did it in principle. They referred to it before the courts, and they made the courts listen to them finally. And also, just I wanted to remind you to the students that there was a very cool system developed by the Council of Europe, which is called HELP system. It is the Human Rights Education for Legal Professionals. There is a very good course on labor rights and human rights, and the big part on European Social Charter. And what is mostly precious, that there are a lot of links on jurisprudence of the European Committee of Social Rights, both referring to the reports and also to the collective complaints. So it might be really helpful for those who do want to promote labor rights on the national level. So here I stop my own question, and thank you all.
Yes, so Katarina, if you are still with us.
Yes, thank you so much for the input and for the suggestions. And regarding the question, although I am not entirely sure, but I would say that from what I remember, it was like you were suggesting. So when the court cited the European Social Charter as obiter dicta, perhaps this could be from the initiative of the court itself in the way that court cites a right to housing, Portuguese constitution, and then the right to housing is also contemplated in the European Social Charter. So that would be obiter dicta, just to reinforce the reasoning. But perhaps I would say that when the court engaged directly with the articles of the European Social Charter, most certainly that would have come from the parties themselves that have argued the violation of the Charter. I think that was what happened in the cases that I've cited of the ordinary courts. Although perhaps in that the decision of the Portuguese Constitutional Court that I've cited, the dissenting opinion, in that case, I think that the citation of the Charter might have come from the judge herself, citing of the European Social Charter. But still, I think that a lot has to be done. But of course, this is good news, the fact that we have some decisions that even if obiter dicta, but they are starting to cite the charter. So hopefully in the future we'll have more, but still I think that the sharp, clear-cut division between the abundance of citations of other instruments that are related to other fundamental rights as compared to social rights, it's quite striking, and I think that we should keep up the good work of enforcing and teaching our students about the European Social Charter as well. Lawyers don't know about the European Social Charter if they have not been taught about that in the university. So thank you so much for your suggestions. I really welcome them. Thank you so much.
Yeah, thank you, Katarina, for your answer. I don't know if other speaker want to reply to this question, but it's pretty general actually, because also, I don't know, Cristina or Lorenza or...
I can give an answer.
In the microphone, if
Yes.
not, they don't. Sorry.
As I already said, I search heavily in my with the help of my special program provided for lawyers in our case law references to the European Social Committee's case law in all the courts, all the levels of the courts, and I found only one. No. As I said, obiter dictum. I don't know. For me, it is not such a relevant, because even in Romania, by the way, I feel better after the presentation of the Spanish. I feel a little better.
Exactly the idea, to keep it.
But in fact, I think the conclusions are optimist, because they joined the collective complaint procedure. So this is good news, wonderful news, and their Supreme Court acknowledge the priority of, as far as I understood, the priority of the treaty, which we have in Constitution. So, well, you know, they say mixed signals. But and I found for me, for my point of view, but maybe I'm wrong, and please feel free to say the other. Only citing the charter without adding value, it is not so relevant. We have also this. Our courts, they know that there is the charter, and we have some general. Tailored rights there, and it's very nice to put them in the decisions, but without the European Social Committees, and I think this pattern, it reflects in a way at the national level what is happening at the European level, because it's the same at the European, as far as I know, the Charter of Fundamental Rights of the European Union makes reference to the European Convention of Human Rights, but also to the case law of the European Court from Strasbourg. It makes also reference to the European Social Charter, but not to the case law of the European Social Committee. Am I wrong? Well, so as we see, there is a symmetry in a way. This pattern is reproduced at the national level. So huge references to the charter, but only in an ornamental way. So as I said, to respond to answer to the question, I found only one or two references to the European Social Committee in the huge, massive number of decisions. European Social Committee conclusions, some conclusions, some case law, coming in an obscure, coming from the plaintiffs, from the parties, from the lawyers maybe, so not from the court, in a very obscure, I don't know, low-level court. Somewhere in Romania, I don't remember, I noticed that, but I found it interesting because there is an interesting reference, and it was a reference which in a way suggested the direct effect. It came as a solution to the contradiction between the less protective national law, domestic provision, and the protection provided by the Charter. So I found that, and maybe I'm sorry that I haven't cited it, because I think we have an expression in Romania: with one flower we don't have spring. So let's say it's a good example, but it's very I think it's a good example from where to not expect impressive acts. Sometimes this reference comes from the very obscure places, so maybe the not so notorious scholars, not so notorious lawyers, they try to find solutions. So they've made the research deeper, and they find the European Committee of Case Law.
And if I may, I don't want to spoil tomorrow's presentation by my colleague Claudio Panzera on the Italian system. But what I can tell you is that when the Italian Constitutional Court for the first time considered the European Social Charter as a parameter for Italian legislation, the referring judge was explicitly was explicitly sollecitato. I can't find the word. Sorry. Boosted. Thank you. To mention the European Social Charter as a parameter by the lawyer of one of the parties, the plaintiff, and this lawyer was a colleague of mine, an international law professor who is used to do strategic litigation in the field of human rights. So this tells us that it's very, very important the use of European Social Charter by lawyers. And very, very often also in the Turin tribunals, the European Social Charter is referred to because lawyers that assist trade associations that trade union associations that in turn support individual complaining against a violation of their labor rights, usually labor rights, do know the European Social Charter. So it's extremely important to train students in law, train lawyers, and make this, because at the end, European Social Charter turns out to be a very, very useful parameter for contending the legality, also vis-a-vis the constitution of legislation or of conduct on these issues, on economic and social rights. That's definitely.
Okay, I totally agree, Lorenza's point of view. In Italy, the decision of the Constitutional Court on the European Social Charter that are very recent, because until 2018 we didn't have any decision of the Constitutional Court mentioning the Social Charter. So after 2010 was really a turning point, and some brave judges on the Constitutional Court decided to mention the European Social Charter, and this was a top-down process. So after the decision of the Court of Justice, also the tribunal started to mention the European Social Charter. So it's totally true that we should start from a certain point of view. And what we have noticed also, not on the Social Charter, but on the ILO convention. So we should start a stream of decisions. Sorry, with my colleague Giovanni Orlandini, that is a labor lawyer in the University of Siena, with whom we work together on the international sources. We have checked the use of the ILO convention in the national legislation, and what we have noticed is that once we have an important decision, the court follows. So we have a really stream of decision, it's a sort of copy and paste of decision. And once we have an important statement, then it's repeated. So we should really start, and I think it's more or less what happened in Spain is maybe different. I don't know if Jose want to add something, because I think in Spain was more a bottom-up process. So the tribunal started and then up to the constitutional court. But I don't know, Jose, if you want to add something. Jose, are you still with us? No. Okay. Anyway, as far as I know, because I'm not a specialist on the Spanish legislation, but there it was really a bottom-up process. So they started from the low-level tribunal and then up to the constitutional court and up to the governor when they could arrive to government. So that when they had a government that was keen to ratify the revised charter and the protocol on the collective complaint. Anyway,
I'm here.
Jose.
Sorry.
Okay, was that? No, I was just mentioning something on Spain, but maybe you are the most, maybe you are surely the most experienced one. So I said that in Italy, the process to really enforce the social charter, to increase the effectiveness of the social charter was more a top-down procedure. So it was the constitutional court that started, and then the tribunal they follow. Instead, in Spain, maybe the process was the other way around. So it was a bottom-up process that started from the tribunal and then up to the constitutional court, right? Or can you say something on this? Thank you.
In the case of Spain, the situation is very singular, because Spain does not comply with own rules. No, the civil code, the constitutional court, and other internal laws or acts. Before the constitutional court ruling, the Supreme Court always refused to recognize that the European Social Charter was a treaty and its directed applicability. No. Only after this constitutional judgment, the Supreme Court recognizes the effectiveness, but only through the control of conventionality. But if you compare the case law of Supreme Court and the case law of the lowest courts, the lowest courts, in my opinion, think or considering that the European Social Court is a treaty, it's the great applicability. In this moment, there is a little contradiction, because the lower courts, considering that the European Social Charter is a treaty, has direct applicability, effectiveness, but the Supreme Court, no. Previously, you have to make, or you compare a control of conventionality. This is the situation in Spain. I don't.
Okay, thank you very much, Jose, for your clarification. Anyway, tomorrow we will have a further example of the use of the European Social Charter in the national state. In particular, we will have Belgium, France, Italy, and that's it. We will have two presentations on France, because the French case is quite problematic at the moment, I think, because they really modified the previous jurisprudence, so they are going backward, not forward, and that's problematic. But I don't know if you have other question, remark. No. So I think we can end the seminar for today. We'll wait for you tomorrow morning at 9:30 here in this room. Thank you very much to the speaker. Just one final remark. The work is not over this evening because we will have the scientific committee to organize, so please stay with us. Thank you and see you tomorrow. Bye.
So, at 6:30, Lorenza, if you want to participate at the scientific committee, you are welcome. Just